Good afternoon, everybody. My name is Andrew Swirling. I'm here with Lauren Levine. Lauren and I are partners at Garfunkel LLC, and we're here to give today's presentation, No One Showed at the Office Today, Challenges and Best Practices for Employers Confronting a Remote Workforce. It's become increasingly common for employers to have employees work remotely, particularly in light of technological advances that have made it relatively easy to perform many job duties outside the confines of a traditional work site or work office. With the COVID-19 pandemic, however, working from home has become even more commonplace and is really ratcheting up. Also referred to as telecommuting, remote work includes any work performed from a location away from the employer's central workplace, often these days the employee's home. While some employees may participate in formal telecommuting arrangements with their employers, other employees, as I'm sure you've experienced, work some hours at home each week or work from home intermittently. Even before the COVID-19 pandemic changed the work from home landscape as dramatically as it has, many employers and employees chose telecommuting arrangements for the benefits remote work provided, including reduced overhead and operational costs, including office space rental. Use as a recruiting tool to attract new employees. Very importantly, depending upon the type of entity, nationwide hiring opportunities and the ability to pay lower market rates, reduce commuting costs and stresses of commuting. Very importantly, this day and age with labor shortages, increased retention, productivity, loyalty, morale, and basically improved work-life balance. The flip side, however, is that telecommuting also creates potential challenges and risks for employers, such as wage and hour compliance with the Fair Labor Standards Act, including ensuring that your employees' hours are accurately tracked and compensated. Questions on whether telecommuting qualifies as a reasonable accommodation under the American with Disabilities Act. Very importantly, less control over where a remote employee stores confidential information, PHI, trade secrets, and other information security issues. Potential discrimination claims if employees are not treated the same as, if employers do not treat all employees, telecommuting requests the same. And finally, just general challenges associated with remotely managing employee performance and other aspects of the employment relationship, including productivity levels. Today's presentation will address some of the common issues that you're all facing dealing with remote employees and deliver to you some best practices for addressing these issues as the growing trend of telecommuting continues. I'll stress that Lauren and I will take questions throughout this presentation. If you just click on the Q&A section on your screen, we'll answer the questions the best we can. If we don't use the chat piece on the menu. If we don't get a chance to answer your questions during the presentation, we'll know who asked the questions and we'll reach out to you after the presentation to answer them. I'd be remiss if I didn't give a little shout out to Garfunkel LLC. In short, we've got 85 plus lawyers in 4 states, New York, New Jersey, Connecticut, and Florida, with offices 2 in New York, Great Neck, and Albany. Lauren and I are members of our rather robust and growing employment law practice group, which led us to give today's presentation, as well as other presentations we've been giving for years, complimentary presentations to our clients. Just one thing I want to point out about Lauren and about myself is that while we do employment law counseling on a day-to-day, putting out fires as they arise with great frequency, we're also litigators and trial lawyers. And we use our litigation experience and perspective in guiding our clients on a day-to-day, because when you litigate a case, let alone try a case in federal or state court, you see rather vividly what a client did well in responding to a situation and what a client did less than well in responding to a situation. And we use that information that we gather in litigation to inform our day-to-day counseling and helping you out as questions do arise. So with that said.
So as the landscape of the office has changed to include many companies allowing their employees to work from home or other locations, it's become increasingly important to have policies that surround what the rules are and the guidelines are for allowing people to work remotely. Couple of reasons why you want to have a well-drafted telecommuting policy. First of all, it defines eligibility to telecommute. Some companies, the whole office is telecommuting these days, but some companies have certain defined eligibility, such as, you know, maybe part-time versus full-time, who can work from home in those categories. Certain jobs may be amenable to working from home, and so certain jobs may be those that you're allowing telecommuting, while maybe others need to be done in the office. And something else I've seen is allowing employees to become eligible to work from home after they've been with the company for a certain amount of time, so that they have a track record, so to speak, before you allow them to start working from home, where it's a little less easy to, you know, assess their productivity sometimes. The policy will also set up your specific procedure for how to request telecommuting. There are times, and we'll get into it more specifically later, where working from home or telecommuting may be considered a reasonable accommodation. So you want to make sure that either in your general policies, if you don't have telecommuting, or in your telecommuting policy, that you address and direct employees to your reasonable accommodation policy. And again, we'll get into the specifics of how that might happen. And it explains the conditions of your authorized policies if you have a written policy. For instance, as Andrew mentioned earlier, some companies are working, everyone is working full-time from home. Some companies have a hybrid arrangement where you need to be in the office once a week or twice a week or whatever it is. These policies will really set those ground rules for your employees. The most important thing is that these policies need to detail what the employee's responsibilities and what the employer expectations are, so that you can have a successful work from home or telecommute policy. One of the most important things is, what are the employee's work hours, right? Those may change when you're working from home as opposed to working in an office. One of the other things we've seen is not only the amount of work hours is an issue, but when does an employee have to start working? When do they end work? We've had clients who are hiring employees that live in different states, and issues that have come up are issues such as, you know, an employee, for instance, is in a different time zone, and you have to make sure when you discuss start and end times that you are speaking about the same time zone. We've had that problem, clients have had that problem with out-of-state employees, where they weren't clear about, you know, what the starting hours were and what time zone they were in. You have to think about lunch breaks. If you are in a state where lunch breaks are required or certain other breaks are required, you need to make sure that if your employees are working the hours that would require them to be able to take a lunch break, that they're still doing that from home. You want to discuss accessibility during work hours. I've had clients have difficulty finding employees who are supposed to be working from home who are not responding or communicated when they're needed for a work assignment or issue. And even worse, have seen employees posting on Facebook or Instagram that they're out doing something else during what's supposed to be their working from home hours. One of the things we've seen that's helpful in that way is some sort of frequency of communication being required with the manager, or some sort of check-in being required of the employee. We'll get into later the Fair Labor Standards Act and recording of time. You want to make sure that you have recording procedures. It may be your regular procedures, maybe you use ADP or some other company where your employees can sign in from home. If you don't, and there's some other method that needs to be used, that needs to be clearly defined. You want to talk about equipment. Whose equipment are the employees using from home? Are they using yours? Are you giving them laptops? Are they using their own equipment? You know, what are the parameters of that? Another big issue is safeguarding employer information when an employee is working from home, just the way you would in the office. If you're obtaining PHI or other confidential information, you want to make sure that that's being safeguarded and protected when the employee is working remotely.
There's two questions on the board. One, will we be speaking on how best for teams to orient and set employees up for success remotely/hybrid? The answer is yes. That's towards the tail end of the presentation. And then another question relevant to what Lauren was just talking about: what about for salaried employees? Do you define start and end time? And the answer is, it's no different where the workplace is located. If you were going to do that for that particular salaried employee, if they were on site, you do the same if they're working remotely. That basic, exchange is unchanged. regardless of the remote arrangement.
And the question of non-exempt versus exempt depends on where you are. New York actually doesn't distinguish between exempt and non-exempt employees on the lunch breaks, but obviously there's a host of different ways that you can have flexible work schedules. And again, we'll get into it later, but the Department of Labor has said if you're giving someone a flexible arrangement where maybe they work a couple of hours in the morning and then they take a large gap in the middle of the day for whatever other responsibilities they need to address, and you've given them that flexibility, then it may be a different scenario. Maybe they're not working the amount of hours they would need to be eligible for a lunch break. So you really have to look at what it is that you're designing and what flexibility you're giving the employees to determine whether or not they need lunch breaks or other breaks. You know, me personally, I've seen a lot of employers still want to know what the work hours are going to be if someone's working from home, because it also coincides with that accessibility issue, right? If you know what someone's work hours are, you're not going to be frustrated when you can't get them on the phone at 9 a.m. if they don't start till 10. But if you have an employee that you're looking for and they're not answering their phone, and you know you've said your work hours start at 9, that's another way to sort of make the work from home or telecommute arrangements work. But again, many of these things are a judgment call. You also want to talk about how to deal with maintaining equipment. If you're giving the employee equipment, what happens if an employee leaves, getting the equipment back? I know so many times employers want to try to dock pay or do something else until an employee gives equipment back. As many of you probably know, you can't do that. So you want to make sure you have rules surrounding the return of equipment, maintaining equipment, what happens if it gets damaged. A good telecommuting policy will also set out the employer's responsibilities, right? What equipment are we going to give the employees? Cell phones, computers, office supplies, are they going to be, you know, many of us are doing mostly electronic work, but what if they need supplies such as paper? You need to work those terms out. What technical support you'll provide if there is something wrong with the equipment? What can they do working remotely where they're not in your office and maybe don't have instant access to someone to look at their equipment? You need to make sure reimbursement work expenses are addressed. In New York, any agreement to pay work expenses would include reimbursing for the office supplies and those sorts of things. So you need to make sure that's clearly defined what the reimbursements are and whether you have a reimbursement policy. If an employee is going to be using personal devices, but you still need to access the information or sometimes, you know, get onto their screen or interact in some way where you're going to be accessing their personal device, that needs to be addressed too, and that needs to be in your policy. That maybe there's not the same expectation of privacy if they're using their personal device for work reasons. You should also, very importantly, let employees know that the company has the discretion at any time to stop the arrangement where someone's working from home, whether that be because the particular employee is not productive or whether at some point you're going to stop allowing telecommuting. It should be very clear to the employees that it's in your discretion, you know, when and for how long these policies may be in place, whether it's generally speaking or for particular employees who are not productive. And always, you know, as Andrew said, you know, make clear that all your regular policies govern the workplace. Just like we were saying, whatever happens, your general policy of work hours, any policies you have, you want to make clear to any employees working remotely that all of your employment policies still apply during that period. So one other issue that's come up a lot is needing signatures or, you know, some other information that's usually in hard copy from employees. And many companies have switched to electronic signatures and electronic documents even before the pandemic, but even more so now that we have remote applicants. People are doing interviews by Zoom and remote employees. So many of the documents that you may need to exchange with your remote employees or applicants can be done electronically and are being done electronically. And what am I talking about specifically? Anything from employment applications, consent for background checks, new hire paperwork, you know, tax documents, immigration status documents, employee benefits, very importantly, handbook and policies, and any notices required by law. All of these things are being, in many offices, exchanged electronically. Many employers have systems for doing all of these things electronically. And there's some risks associated with using electronic signatures on, whatever documents you're talking about, whether it's benefits enrollments or handbook acknowledgement or other legal documents. And so we just want to talk a little bit about the guidelines that exist for use of electronic signatures in the employment context. There's 2 federal laws that guide the use of electronic signatures in the workplace, and those are the e-Sign Act, which is the Electronic Signatures in Global and National Commerce, and the Uniform Electronic Transactions Act, that's the UETA. They both define electronic signatures as electronic sound, symbol, or process that is attached to or associated with a record or contract and executed or adopted with the intent to execute the document. Some tips for best practice, many of which are legally required. Just as with hard copy documents, you may have employees who challenge, oh, I didn't see that policy, that's not my signature. So how do we deal with that? Certainly your documents where you're using electronic signatures should have consent language indicating that the employee understands and consents to conducting this business electronically. That's actually required in order for the signatures to be sufficient under the 2 laws I just mentioned. Ensure the documents are actually signed by the employee electronically. Many times we get a file from clients and there's a handbook, again, a handbook acknowledgement comes to mind, unsigned, and the employee's going to say they didn't get it. Make sure you're actually enforcing your electronic signature policy and that you're getting all of these things signed. Consider using some sort of software or technology that confirms that the signature is verifiable. There's digital signatures, biometric signatures, signature capturing devices. There's several ways, many of which are very accessible to employers, to make sure that the signatures you're getting are verifiable and that an employee is not later going to challenge the validity of the signature. Also, electronic documents can be easier to alter than when we were using only hard copy documents. So you also want to make sure that documents have not been altered. And sometimes that's very broad to do because you're going to get a lot of documents back depending on how many employees and how many documents you're signing electronically. So there's also software that can do that, encryption devices, to make sure that the employees can't alter the documents. And obviously that's important in many areas, including, if they're sending back a contract or other document that guides the terms of their employment. Again, just like with telecommuting, you may want to have, if you're using a lot of electronic documents, you should have a policy in writing about how the logistics work of the electronic signatures and your electronic document keeping. You also want to look at any state laws that may govern this area as well. One other thing I sort of mentioned briefly is posting notices. There's still legally required notices. For instance, let's say your FMLA notice, the general notice everyone has to post in the workplace. So the Department of Labor recently issued guidance talking about notices that are individual one-off notices that you have to give to employees, and general notices, like I said, your FMLA and other posters that you have. So the Department of Labor has guidelines for if it's a one-off notice that maybe you're supposed to directly email to the employee, or what if you have some of your workforce in the workplace and some at home, you have to have a procedure for giving those notices to your work at home, your work from home or remote employees, and in addition, still have them hanging in the office if you're in the office. So that's something else you want to take a look at and think about if you are going to have a remote workforce and you're going to need to give documents electronically.
Okay, let's talk a little bit about the hiring process. For remote employees, that process likely will take place exclusively online, and some common issues that arise in that context are electronic signatures that Lauren was just talking about, and with increasing frequency, ADA accessibility issues. Signatures, as anyone in HR knows, are important on an application for employment because they indicate that the applicant has read, understands, and agrees with statements that no representation by any representative or agent of the employer creates an implied or expressed contract of employment, meaning nothing that is said has undermined the employee at will relationship, that all of the information provided in the application is true and complete, that any falsification or omission of information may disqualify that applicant from further consideration for employment, or if hired, may result in termination of employment, and that an offer of employment is conditioned on the applicant complying with the employer's requirements, including but not limited to signing a separate disclosure and consent form before any background investigation. Therefore, it's important to ensure that the remote employee actually returns an employment application that's signed electronically or otherwise, because sometimes there's a hybrid process of the, with regard to signing, whether it's going to be online or in person, and that the employee maintains a copy of the signed application in the employee's personnel file. Because Lauren and I, as litigators, we've seen that countless times where we'll ask, let's say, an acknowledgement for receipt or accessibility to an employee handbook or some other significant document, significant as defined by what's going on in that litigation. And we'll just get a copy of the document with no signature. On the one hand, it's a ministerial step. On the other hand, it's a ministerial step that may have significance in a given case. With regard to ADA compliance and ADA accessibility, because employers seeking to hire remote employees are likely to use an online application process, they must ensure that the applications are ADA accessible. Because as those of you in HR know, the ADA prohibits employers from discriminating against qualified individuals on the basis of disability regarding, among other things, the job application process. And the ADA requires employers to provide a reasonable accommodation to applicants with disabilities absent undue hardship. And this may include modifications or adjustments to a job application process that enables that otherwise qualified applicant with a disability to be considered for the desired position. The ADA's accommodation requirements that may apply to applicants will include applicants who are blind or visually impaired, who are deaf or are hearing impaired, or applicants who may have physical disabilities, for example, affecting manual dexterity, which may impair their ability to use a mouse. Online applications that fail to meet accessibility requirements have been challenged by applicants in court. And so some best practices to avoid these types of lawsuits are getting the pre-litigation letter from an attorney, and to ensure that the online application systems are accessible to applicants with disabilities include, and this is something we've seen in a host of litigations over the last several years, following the Web Content Accessibility Guidelines, which are industry guidelines for making web content accessible for persons with disabilities using assistive technology such as screen reading software and captions to access online information. There has been a real spike, and it's gone from industry to industry over the last 10 years or so, plaintiffs, attorneys targeting different industries. The last several years, as we've experienced here at Garfunkel Wild, the healthcare industry, where they'll have a person sit in front of a computer claiming that they wanted to be a patient at a hospital or a medical practice, for example, and they can't fully access the website because of limitations in the technology that prevent them from finding out information about that medical provider. There are easy fixes to this, but you have to ensure that your systems are up to speed with regard to the Web Content Accessibility Guideline, which we've given separate presentations. We just gave one in January on that specific subject alone. But you should also make sure that your technology that you ensure that there's information about reasonable accommodations that would be readily available to applicants with disabilities, by way of example. And you need to provide alternative application methods for applicants with disabilities that would otherwise prevent them from completing the online application. Okay, new hire information and policies. Employers must provide and obtain from remote employees the same information they provide and obtain from other newly hired employees. You as an employer, you can choose to exchange this information electronically, or have remote employees visit the office location to handle the new hire paperwork and orientation. That's that hybrid that I was referring to before. When you do so, you want to have them complete online, much in the way they would do in person, certain documentation. For example, they have to complete their W-4 form, designating the appropriate amount of federal tax withholding. They have to complete the I-9 form. They have to provide the information required under any state wage theft prevention law where the employer operates or employs the remote workers, which may include information about the employee's wages and regular pay days, the employee's overtime rates of pay, if any, and the name and doing business as name, address, and telephone number of the employer. Importantly, you should also include the employee handbook and any other policies distributed to all employees at the time of hire, as well as signed authorizations of receipt of those documents, as Lauren pointed out before. Because this is a critical component. I know I'm repeating myself on this, but we have a bunch of litigations pending right now where we've been sitting across the table at a deposition. Well, isn't it true you received this particular handbook or this particular policy? And the person says, or did you have access to it online? If it was, some of these policies are many pages, and the person goes, no. And there's no signature, electronic or otherwise, to refute that. So again, I'm stressing that point. Employers must be diligent about obtaining remote employees' consent or acknowledgement for things like mandatory arbitration procedures, anti-harassment policies, and anything else the employer may later need to prove the remote employee understood, consented to, or acknowledged those policies or protocols. When handling electronic communications with remote employees, you as an employee should ensure emails accurately describe and underscore the importance of the policies the employer is communicating and require an affirmative response from the remote employee, including a signed acknowledgement, or have them click a box on a computer screen that then gets recorded. You can use a tracking log to monitor whether employees opened the email and actually clicked on the links to read the policies, and you can follow up with employees not appearing to have opened the policy. That's very important because sometimes just merely opening the email doesn't mean that they necessarily, or that you have proof that they necessarily read, understood, and consented to whatever was in that email, whatever policy was in that email. You want to have procedures in place to maintain the integrity of the process, to curtail the possibility of remote employees later claiming when there's a dispute they didn't receive or acknowledge that particular policy.
Before we move on, I see there's a question I've been asked to restate the two federal laws that apply to electronic signatures. The first one is known as the E-Sign Act. The formal name is Global and National Commerce Act. The other one is the Uniform Electronic Transactions Act, also known as UETA. So as we mentioned earlier, working remotely has also implications for wage and hour issues. Keeping track of employee time is important, and unfortunately a trap for the unwary. We've seen certainly an uptick in litigation in this area. Generally speaking, the FLSA requires employers, and state laws require employers to pay employees for all hours worked. Work not specifically requested but permitted or suffered is considered work time. This applies to remote work as well. I'm sure many of you have dealt with this issue in the office, but it also applies to working from home. And when employees are working from home, sometimes the lines are blurred and it's not clear when are they working, when are they not working. And that's why, like I said earlier, you want to define that. But even outside those hours, if you have reason to know or reasonable belief that someone's performing, a non-exempt employee is performing work outside those hours, including any overtime, it must be counted as time worked, even if it wasn't necessarily anticipated or authorized. And that becomes a little trickier in the remote work context, even though we also deal with it in the workplace. Again, the rules, the FLSA rules and state rules apply in terms of keeping records of non-exempt employees' work time, but it becomes especially important for remote employees where it may be difficult sometimes to ascertain when work stops and when work began. You should take certain steps to make sure that you're keeping accurate records from your work from home employees, non-exempt employees, including, how many hours they worked. The Department of Labor has recognized that working from home and remote work has become very popular, since the pandemic, and has issued some clarifying guidance on some of these issues. First of all, employers must pay for all work they know or have reason to believe is being performed, even if work is unauthorized. And as many of you know from just, regular workplace issues, you can't dock employees' pay for working overtime. You can discipline them in other ways, but you can't dock pay. They must be paid for that time. Employers have the obligation to make sure that that's happening, and they can satisfy their obligation to exercise reasonable diligence to track hours by providing reasonable procedures for reporting in, unscheduled work to the supervisor or to HR. The Department of Labor has talked about what those reasonable procedures are for keeping track of hours, including, work that wasn't anticipated or authorized. It has said that reporting procedures are not reasonable if they prevent or discourage employees from putting in time that they worked, if they don't provide training to the employees on their procedures, or it requires employees to waive any rights to compensation. So it's important that you don't have any policies in place that discourage your employees from working, from reporting work time, or that in any way tells them that they have to give up compensation if they wind up working hours that weren't anticipated. And make sure you have a clear policy and that your employees are trained in this area. Employees are not required to take impractical steps to figure out that someone's working from home, so that's why it's important if you have these available reporting procedures and you have some of the other defined policies we talked about, it's not on the employer if they're not otherwise notified of additional work that's being done. That's why you want to have all these parameters in place. Any employees who are working from home as part of reasonable accommodation, which we'll talk about, or pursuant to any contract, they need to be paid the same salary that they would if they were working in the office. If not, for non-exempt employees, you're only required to pay working from home for the hours they actually worked, and that's another reason that these policies are so important. And just like in the office, if an exempt salaried employee works any part of the work week from home, you'll still have to pay them for the complete week. And also, in terms of paying non-exempt employees only for hours worked, you still need to be making sure that they're being paid minimum wage and that they're being paid for any overtime that you've permitted or suffered or authorized them to work. Like I said earlier, sometimes employers will allow flexible hours, and maybe an employee has a large break in the middle of the day to allow them to work remotely. Even though that's inconsistent with the other things that I'm stating, if someone is not working in the middle of the day, that doesn't count as work time. You can stop and start, and the DOL has said, they want to encourage flexibility. So in those situations, you can sort of start from the person's first activity that they did and count the time appropriately. You want to have, like I said, you want to have policies and procedures in place for this. You want to have your timekeeping policies updated to include what happens if employees are working remotely. You want to prohibit off-the-clock work, however it is that you define, clocking in. You want to, like I said, have a reasonable procedure for reporting unscheduled work. As with your regular policy, you want to make clear that any falsification of time records will be subject the employee to discipline and most likely termination of employment. You want to have your managers and supervisors reviewing the hours, making sure things are consistent with the amount of hours the employee is scheduled to work, or the amount of overtime you've authorized, or they're being able to get in touch with them, seeing some other level of productivity. Maybe you're in a business where hours must be recorded or certain projects must be done. You want to sort of keep an eye on that and track the hours versus the productivity and make sure everything is in line. Again, you want to have an agreement on what the work hours are, and maybe sometimes working from home, you might have on-call hours, which you maybe wouldn't have in the office, but maybe you're going to let your employee work only till 3 o'clock, but they have to be available if you need them. You want to work out the arrangements of what those hours are and where you're going to have sort of on-call or other types of arrangements. And you want to also have a rule that prevents the employees or prohibits employees from working outside the schedule that you've arranged, so that they're on further notice that if they work outside that schedule and you're not aware or authorizing that work, that's time that they may not be paid for. If it's not work that you reasonably should have known or requested that they perform. You want to include things such as meal times and personal breaks, preparation time, is logging into their computer included. There's a lot of different things to think about. And any waiting time. If you require them to be on call and they have to be, at their computer, that may be something that's compensable. If it's just that they have to be available but they can go anywhere they want, maybe it's not compensable time until you actually call them and they start working. So those are different things that you want to think about. And you also want to cross-reference the telecommuting policy with any policies you have related to recording time for employees working remotely. As we said before, when many of you I'm sure know that telecommuting may be considered a reasonable form of accommodation. The EEOC has specifically issued guidance on this and even before the pandemic had recognized telecommuting may be a reasonable accommodation. The ADA doesn't, and the state laws don't require that you give all of your employees the option of working from home. If you're not a business that offers working from home, we're not saying the ADA requires that you allow everybody to work from home, but certainly a couple things to think about. If you have a work from home policy, you cannot exclude employees. You have to have the same opportunity for employees with disabilities to participate. Even if you don't have a telecommuting policy, again, the EEOC has recognized working from home or remote working as a reasonable accommodation. So if someone requests working from home as a reasonable accommodation, the answer can't be, oh, we don't allow telecommuting. So you have to remember that it does have to be something that's considered as part of the interactive process. You should determine sometimes whether, whether it's reasonable for an employee working from home before you even engage in the interactive process. You want to consider what that would look like. You then are required to engage in the interactive process with the employee to determine whether it really is feasible for them to work from home. But it's something you want to think about before engaging in the process. If you know you're about to have a conversation with an employee who's requesting an accommodation to work from home, you want to look at their job description. You want to look at the things that they can do in the workplace. You want to talk to them in the interactive discussion too, but you want to also be prepared for that discussion. Some of the things you want to talk about are, what things are difficult. Maybe they can't drive to work, but they can do the job at home. What are the things making it difficult for them to work in the workplace? How the job can be performed at home, or whether there's any other accommodations short of working from home. If you're generally not a business that offers working from home, what other accommodations may address their needs? So again, just like any other accommodation, you want to engage in the interactive process, but because this may be fairly new for many of you, you really want to look at everything before you get into that discussion, including, look at the job description, identify and see what their essential functions of their job are to determine whether they can do it from home. There are certain positions, and this is, we got a lot of calls, especially during the height of the pandemic. There are certain positions that can't be done from home, right? A food service person, many clinical people can't work from home. Truck drivers, cashiers, there's a lot of people that can't work from home. But it's certainly in the healthcare context, a lot of questions we got had to do with clinical people that couldn't provide services by Zoom or some other electronic way. And certainly now that people are largely back in the office, they probably fall into a category where they're not going to be providing services from home. So it is the case that there may be some employees that you just can't offer that accommodation, and that's why it's important to look at what you can and cannot offer. You want to look at whether they can be supervised at home, whether there's any tools or equipment that need to be used in the office that you just can't offer to them at home, whether there's a need for face-to-face interaction in their job. We have some employees who may go out to clients every couple times a week, and they can't be doing that from home, or maybe they can do it from Zoom, or maybe they're doing an inspection that requires you to be in person. You have to really consider that person's job and what's required. Whether there are on-site documents that can only be accessed on-site. Some medical practices, maybe you use a paper chart before you put the patient in the room. Maybe that's not something that can be done from home. So maybe your receptionist can't work from home, but maybe your call center people scheduling appointments can. So you really have to consider the specific job you're looking at. You can't just deny an accommodation to work from home because there's some interaction required. If it's not a major function of the job to interact in person and whatever interactions need to be done can be done by email or Zoom or whatever electronic means. You can't deny an accommodation of working from home just because some of their job involves personal interaction. There may be times where some of their duties can be done on site, some done remotely, some can't. Maybe there's arrangements where they work part-time from home and part-time in the office. That's something else to consider. An important thing, just like with any other regular accommodation, any other accommodation, I should say, you're not required to remove a major function of the person's job just to allow them to work from home. So that's something you should certainly consider when you're looking at the job description. Are there things that are major functions that they can't do from home, or can they largely do their job from home? If all that they can't do from home is just a minor function of their job and you can reassign some responsibilities, that is an accommodation request that should be granted. Again, as long as they can do their essential functions of the job. Courts, if you're ever challenged on denying an accommodation request, courts don't look at, does the employer just want their employees in the office? They look at, is it feasible to do the job from home, and can the person have been granted that accommodation to work from home? It's going to be very hard to argue if you have some people working from home and you deny an accommodation for someone in a similar or same position. It's going to be very hard to argue later on why it wouldn't have been a reasonable accommodation. So you want to make sure you're applying these rules with consistency as well. You may get discrimination, because we've had discrimination claims, come lately from clients who are being accused of failing to accommodate with a work from home request. And to minimize that possibility, again, you want to act consistently. You want to look at all the things that I just stated before denying a request. You can't just say to an employee, oh, we don't allow work from home, and that's the end of the inquiry. You are required to engage in that interactive process. Ultimately, maybe you're a business who can't offer work from home, but you must consider it and engage in the process. Again, this is why it's important to define who's eligible. And are you going to have to waive some eligibility requirements? Maybe you have a new employee who needs to work from home, and you have a policy that you can only work from home after you've been working for a year. You may need to waive that in certain circumstances in order to grant a reasonable accommodation. And you want to train your managers. You want to make sure your managers understand that so that they don't just reject requests out of hand. And you should have a process whereby your accommodation requests, including working from home requests, don't only go to the manager, but they go to your HR or some other higher level employee, so that we're sure that all of the things we talked about are addressed when you're receiving such a request for an accommodation.
Just to piggyback what Lauren just said on this interactive dialogue or this interactive process, Lauren and I, as we speak, have several matters and litigations on that very narrow topic, where the employer, and it could just be a line supervisor who denies a request, doesn't go through HR or somebody higher up in management to resolve that issue. Even you have to have that conversation with the employee. Even if in your gut and your instincts scream out, it's not going to work out where there's some reasonable accommodation, you still have to go through the steps. You still have to document that you went through the steps. Because, again, we have a bunch of matters now where that dialogue was not necessarily as sufficient as it should have been. And it's a shame, because the proof that we have before us reveals that dialogue would not likely have led to some positive outcome in the form of an accommodation that was workable. So again, when those instances, when those tension lines are created where the employee needs an accommodation or is requesting one, don't give it short shrift. Give it your full attention in playing it out. And sometimes, look, most employers, notwithstanding cynical types, are decent-minded. They want to have it work out with their employee and have come up with some creative solutions when they have those dialogues. So they are otherwise worthwhile to have, aside from just from a legal standpoint, you should have them. All right, tax and employment law considerations. Importantly, when one of your employees is working in another jurisdiction, it creates a physical connection between that employee and that jurisdiction that may give rise to various tax and related issues that are in need of consideration and handling by you as the employer. First is the issue of whether state income tax should be withheld from wages. And dispositive factors relating to that include, are the employer's business operations conducted in the same state as the employee's residence? Does the employer conduct business in the same state where the remote employee performs work? Does the employee perform work outside of the state from his or her home or from a fixed business site of the employer? And if it's from the employee's home, is that work done for the convenience of the employer? And I'm only identifying the variables that you need to take into account in resolving the income tax issue. Second, employees may be subject to state corporate income tax. Third, in addition to potential tax implications, you should be aware that the laws of the jurisdiction in which your employee is working may trigger other obligations, including those relating to workers' compensation insurance and unemployment insurance. As for the workers' compensation insurance, you need to confirm whether or not the jurisdiction where your remote employee works will require unemployment insurance. The general rule is that this is required when the employee performs services. And a failure to satisfy this mandate, it could lead to sanctions by the other state for noncompliance, and even more costly, it may lead to substantial exposure to you as an employer if your employee gets injured during the job. So if you're based in New York, employees in Texas, and he trips and falls while working on the job and suffers substantial injuries and you don't have workers' comp insurance, you're going to be on the hook for that. So this is something you need to look at. And finally, generally unemployment insurance is required in the state where the employee performs services, but you need to look up the rules and regs in the particular other jurisdiction in order to ensure compliance by you. Okay, managing employee performance and conduct. Somebody had asked up front if we were going to touch upon these particular issues, and we're doing so now. Because some of these issues that we're going to cover at this point go to just some technical compliance and employee privacy and data and privacy and monitoring concerns, but part of it also has to do with employee engagement, which in this day and age of labor shortages is something that is taking on even more importance on a day-to-day. So first, compliance with employer policies. Employers should inform the remote employees in the applicable telecommuting policy that Lauren had discussed up front, or an agreement that remote employees are obligated to comply with the employer's policies, and that a failure to comply with those policies can result in the normal course, if they're on site, discipline, termination of the telecommuting arrangement, or termination of employment. And employers may choose to mention specifically certain policies of particular importance or significance to remote employees, such as anti-harassment, standards of conduct. You know, one would think, well, sexual harassment on the workplace, maybe there's less of it because people are working from home. We've seen a surge of online sexual harassment during Zoom meetings, face-to-face, online exchanges. So you may want to draw particular attention to those policies to your employees who are working remotely. And employers should discipline remote employees for failure to follow employer policies or other misconduct. Again, it's treated no different than if they're working on site. With regard to employee data, privacy, and monitoring remote employees, their activities, their conduct, and performance, let's face it, it can be challenging because they're not physically at the same work site as their manager or their supervisor. And understandably, employers will sometimes have concerns that remote employees are abusing their telecommuting arrangement. Maybe they're not actually working from home to the extent they should be. And many employers struggle with the most effective way to monitor and manage remote employees' productivity and performance. Some managers choose to rely solely on regular emails or phone calls or video conferences and in-person meetings where practical in order to keep track of their remote employees reporting to them. However, some employers have chosen to manage aspects of employee productivity performance in other ways by monitoring the remote employees' use of the employer's electronic communication systems. This could include task monitoring software or other methods to review the employee emails, including emails sent to or from the employee's email systems, or emails sent to or from an employee's personal email account, accessed by the employee via the employer's computer systems. They can also, you as an employer, monitor internet usage, including checking out what sites your employees are visiting during work hours. Employees can also block employee access to inappropriate or illicit websites from the employee's computer systems. You can also, as an employer, as a monitoring system, track employees' keystrokes while using the employer-owned computer. You can also, depending upon the particular job, you can monitor employees using a global positioning system. This doesn't usually apply when you're talking about people who work behind the desk, but it's another mechanism that can be used to monitor employee activity during work hours when they're working remotely. Now, while electronic monitoring of email, internet, and login activity may be particularly appropriate for remote employees, the risk of invading a remote employee's privacy can be greater because oftentimes the employee is working in their home and sometimes even using their own equipment. So some best practices for workplace monitoring of remote employees and minimizing the risk of liability include implementing a clear electronic communication systems policy where you set out those guidelines, notifying remote employees, much as the way you do or should do anyway with on-site employees, that they have no expectation of privacy when using the employer's email or computer systems, and that their electronic communications using these systems may be monitored, right? You want to let them know that. And you want to explain to them the business purpose of the monitoring policy, such as tracking their efficiency and productivity, protecting against disclosure of trade secrets, ensuring compliance with federal and state laws and company policies. So let them know why you're doing it, that you're not just acting like Big Brother for no other reason, that there are pragmatic reasons why you need to monitor their use of the computer systems. With regard to confidentiality and trade secrets, let's face it, you want to take steps to protect your trade secrets and other confidential information with remote employees, again, much in the same way you would with on-site employees. And this includes providing information security training and instructing your employees to secure any employer property, maintain confidentiality by using passwords, and lock file cabinets if applicable. We had one instance where somebody was working remotely, receiving faxes at home containing PHI with the fax machine in his dining room, accessible to family members. Let's say we swooped in and fixed that. But you want to have your employees maintain regular antivirus updates and computer backup. You want your employees to keep the passwords safe and not share them with other members of the household who may otherwise, at least theoretically speaking, have access to the trade secrets or confidential information. You want your remote employees to avoid keeping confidential information in a place where family members or visitors to the employee's home can view or access it. Again, it sounds like common sense, but as Lauren and I know as litigators, common sense isn't so common. So these are refrains worth repeating to your employees working from home. You want them to be instructed and follow up on how to dispose of sensitive documents properly. Do they have a shredder at home? Do you have a protocol where they bring it to the office where it's going to be shredded? So you want to give them these guidelines in order to help them and then help yourself with regard to maintaining the confidentiality of proprietary information and trade secrets. Finally, with regard to engaging and communicating with remote employees, it's much more challenging to engage and pull in and maintain that, deep tie with an employee who's working remotely. But in addition to ensuring that the remote employees understand and abide by all of your policies and are working remotely in a responsible manner, effective communication is an essential part of managing your remote employees. And to ensure that your remote employees are engaged and productive, managers should, and there's a host of things I'll bullet through, set out goals and expectations at the beginning of the remote relationship. You're going to have your policy, as Lauren pointed out, but have a conversation. Answer questions about some of the nuances of that remote working relationship. So there's a clear understanding from both parties as to what's expected. Discuss with the remote employee how performance is measured and at what frequency. There's going to be a feeling of disconnect between the employee and the workplace. You know, you want to try and minimize that. They're not going to have that same feel about how they're doing, good or bad. You have to have a discussion about that and find workarounds to deal with that issue. You want to try and maintain personal contact, and to the extent it's practical, strive for in-person meetings if feasible at reasonable intervals. Even if it's, you know, it's just a lesser or greater, depending upon which end you're coming from. It's a hybrid relationship. Just because you have a remote working relationship doesn't mean that you may not want to have them come in monthly, quarterly, and so on. You want to provide training to remote employees, both on the job and more formally using webinars, online teaming portals, video conferencing, or from time to time, in-person conferences, again, to deepen that or reinforce that connection. You want to include remote employees in employer-sponsored events if feasible. You should include remote employees on any communication shared with the remote employees' peers. You should include remote employees in team meetings using teleconferencing or video conferencing equipment if available. And as Lauren pointed out earlier, be mindful of time zone differences when you're setting up meetings. You know, that 9 o'clock meeting is great if you're on site, but if somebody's in California, you're telling that employee they're waking up at 6 in the morning. They'll do it. They're not going to give you the love for waking them up that early for a meeting that could have been done later. So again, take that into account. Evaluate remote employees' performances using the same evaluation methods that you would do for in-person. Budget in advance for remote employees' travel to meetings, seminars, employee-sponsored events. If you're going to have something in person and somebody's living 4 hours away, because that's doable on a day-to-day, and you're going to have some meeting of significance where their attendance is required, or for morale lifting purposes, some employer-sponsored event, take into account where all of your employees are going to be coming from. Again, you want them to feel that they're on the same footing as those who are on site on a regular basis.
I see there's some questions we just want to answer quickly before our time is done. There's a question, can telecommuting also be allowed as long as productive? Can an employee be asked to work in the office in order to improve productivity? Absolutely, and that's why you want to have a policy in place that makes clear that you're going to be tracking productivity and you're going to be tracking when employees are working, so that therefore you can say, look, if this is not working out, and that's the language I was talking about, that it's in the employer's discretion to end a work from home arrangement for any employee at any time, and you can certainly specifically reference productivity as one of the things you'll be looking at in order to determine whether someone should be able to have a work from home arrangement. So the answer to your question is yes. I see here, what is a large employer's responsibility to provide an ergonomic workstation for a remote employee working from home, or if an employee asks for an evaluation? There is no general requirement to provide an ergonomic workstation. However, OSHA requires that we provide a workplace that's free from hazards and is safe. So it's certainly something to think about and consider, what are your obligations in that regard? And if you have an employee who's asking for an evaluation, talk to them about what their issues are. What is it that they need? Do you need a full evaluation, or can they say to you, look, I don't have a chair at home that's comfortable and my back's hurting, or whatever the issue is. There's been a lot of talk about, workstations at home not providing the same comforts of what may be set up in the office. So it's really a judgment call, but at the end of the day, you need to provide a safe workplace. So you should absolutely engage in discussion with those employees as to what they need and what it is that you're going to provide. Lastly, I see, can e-sign requirements please be mentioned again? There's a lot of best practices, but some of the things I mentioned, or one of the big things I mentioned, is that you want to have consent language in your policy about electronic signatures, and in the documents, when they're getting a document to sign, because they need to agree, the employees need to agree that you're going to be doing business electronically. So under those two federal laws that I mentioned, you want to have consent language in your policy or in whatever document you're going to be sending them, so that it's clearly understood what they were signing. As far as the definition, an electronic sound similar process, in order for it to be considered an e-signature, it has to be attached to or associated with the document, and there has to be an intent on the employee's part to sign. You have to see that there's an intention for them to sign the document. And how that may be done, there's different logistics of how to handle that, but certainly the consent language and an acknowledgement that they understand what they're doing in terms of signing the documents, those are things that you absolutely want to have and are required by those federal laws.
I just want to amplify the answers to two of the questions on the, can telecommuting also be allowed as productive? Just the question I've got. There you go. And can an employee be asked to work in the office in order to improve productivity? Yes and yes, but be consistent. Like if you're going to say yes to Lauren and no to Andrew, you need to have a rationale, an acceptable rationale for that distinction, because you could, depending upon the facts, open yourself up to a discrimination claim. So you can have your employees work wherever you feel in your discretion as an employer they can be productive. But you need to be, you have to be consistent in your treatment of all employees. So that's just an overall answer to that. With regard to the request for an ergonomic workstation at home, usually those types of requests come in the context of a disability issue and requests for a reasonable accommodation for someone who's disabled. So that's the kind of analysis that you're going to have. And if the answer, and I'm simplifying it, is that if they were in the office, you were going to provide them a certain type of equipment to accommodate their disability, and it doesn't create an undue hardship and so on. The fact that they're working from home with consistently, in a manner consistent with the way other employees are allowed to do so, then yeah, the likelihood is you're going to be required to provide that additional piece of equipment, okay? So, you know, again, that interactive dialogue that Lauren described earlier, that's the critical component of this analysis. But if they were otherwise going to get that assistive equipment or ergonomic workstation, if they're working on-site, then chances are you're going to have to provide it at home, but you're going to want to make it explicit in your policy and some agreement that they have to return that equipment, and you know, so you want to make that explicit. So if they decide to terminate an employment the day after you get them this nice piece of equipment, they don't think they can walk away and take it with them and keep it.
Even outside the disability context, if you just have employees, it sounds like you were asking on the whole as well. Andy's point's a good one, because a lot of times we see ergonomic requests and accommodation requests, but even aside from that, you're still obligated under OSHA to provide a safe working environment. So even if you get an employee asking for something and they don't have a disability, even if you get them asking for something because their workstation at home is not safe, that's something still you have to consider, even if it's not in the context of a disability accommodation.
Yeah.
I see now it's 1:04, so we're a little bit over. I think we've answered all of the questions. We appreciate everyone's time, and feel free, our contact information is there. Feel free to reach out if you have any other follow-up questions on these topics.
Thanks, everybody.
Thanks.